Welcome to Amicus, a law review with Jim Santelle, Civic Media's weekly review and discussion of some of the most significant news stories in the areas of law, government, courts, and the aspiration for justice. And now, here's your host, Jim Santelle.
Welcome to this, our weekend broadcast. My name is Jim Santelle, and yes, for this hour and next hour as well, I'm going to be your host on this broadcast of Civic Media, also being carried on 12 broadcast stations throughout the Civic Media communities, throughout the state of Wisconsin and beyond. This is our 91st broadcast, although our second broadcast under our new name, Amicus, a law review. Delighted to have you with me this morning and beyond throughout this weekend for our presentation of issues related to law, justice, and the aspiration for justice in our nation and beyond. As always, we're going to be taking your phone calls as well this hour and next hour. That number is 855-752-4842. For those of you who are new to our newly restyled and reimagined broadcast, Amicus, a law review, a little bit of reintroduction once again. An amicus curiae is an individual and organization that is not necessarily a party to a legal case, something pending in court or beyond, but that party nonetheless permitted to assist a court, to assist a judicial officer by offering some information or expertise or insight that is a bearing on the issues in the case. The phrase, of course, not surprisingly, is legal Latin, and the origin of the term has probably been dated way back to 1605 to 1615. In America, we often see amicus briefs filed at appellate courts, including the United States Supreme Court. And indeed, when those briefs are filed at appellate court levels and at the Supreme Court level as well, they often deal with all kinds of issues important to our lives and livelihoods, including things like social policy, economics, academics, commercial issues, civil and human rights, and many, many things beyond just that. We take our name on this weekend broadcast, Amicus, a law review, from that notion that we are here as a civic media entity to provide some legal insight, some perspective, some assistance, some support, some less direction, but more counsel in the areas that are important in our lives, offering it up to you for your consideration and insight. How do these things in our lives have an impact upon us? What do they mean practically? And how, in fact, should we understand what's going on in our courts? As always, we make some focused identification and hopefully some clear exposition of some of the most important news stories in the areas of law and government, and yes, that delivery of justice to all of us. We articulate, hopefully as well, some explanations, some descriptions of the reasons why, exactly why those local and national and world events are relevant, why they're significant, and why they're meaningful in our lives. We provide on this broadcast an examination and an explanation of the practical trappings, the specific aspects of the legal, governmental, and sometimes the rule of law issues in those news stories that populate our lives. And finally, we offer some instruction, some perspective, some insight, if you will, consistent with the word amicus, on the intersection between law, both procedure and substance, with civic responsibility and engagement in our community, which ultimately is the mission of Civic Media, certainly the mission of this weekend program. Thank you once again for joining me. As always, we're taking your phone calls at 855-752-4842. And I am joined in the Waukesha studio of Civic Media this morning by my excellent producers. Their names are Anya and Abby. Anya and Abby are here with me to make this show go this weekend, and also to ensure that your phone calls, your insights, your questions in particular about the things that are on our syllabus on this, our 91st broadcast, are addressed, and that you have an opportunity to participate with us as an amicus as well, a friend of this radio broadcast, this radio station, as we pursue these many issues. Before we begin and talk about the specific things that are on our syllabus on this weekend, our weekly review of those issues, I want to note, as we often do, that our Constitution provides some direct and relevant contemporary insight into what we do in America and beyond. The very First Amendment to the Constitution says this: Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Let me repeat that. It's important to understand the very first words of the very first amendment to our Constitution, the 10 of them, the Bill of Rights. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Now, in the time since 1791, when that amendment was ratified by the states and became a part of our Constitution, the United States Supreme Court and other lower courts, including state courts, have also taken a look at what that language means. And a lot of that jurisprudence has developed based upon tradition and history, but also based upon the contemporary practices in our nation, understanding that judges live in the real world. I bring that to our attention this weekend on this broadcast of Amicus because we are at a special time in America, often happens in the springtime. We happen to be right in the middle of a number of important observations and events and occurrences inside some of the major religions in America and on the face of our planet. As you know, this is Holy Week for all of our Christian friends and associates. It is also the third week, the Holy Week of Ramadan, for our Muslim friends and colleagues out there. In a couple of weeks, beginning in mid to late April, it is the beginning of Passover for our Jewish friends. And yes, indeed, in mid-April, on April 13th, for our Sikh and Hindu and some of our Buddhist friends as well, it is the observance of Vaisakhi, which is sometimes regarded as the harvest festival, a spring festival. All of those things happening in America and frankly across the planet at the same time. Holy Week, Ramadan, Passover, Vaisakhi, for a diverse and wonderfully to be embraced set of religious entities, people affiliating as they are free to do under our Constitution and to express their religious views, their spirituality as they choose to do without any involvement of the Congress, meant more generally to include the government. That is the affirmation of our Constitution. That's the affirmation of our founding fathers. And we celebrate both the diversity and the wondrous inclusion of a nation where all these different religions and others as well can pursue their faith as they choose to do so, pursuant not only to the assurance that government will not impact, will not affect that pursuit of their spirituality, of their own religious beliefs, and also acknowledging that implicit in that amendment, implicit in every word of our Constitution, is the notion of inclusion and diversity, and the notion that we are better if we are people who embrace those fundamental concepts and understand that it's through diversity that we've got a larger understanding of our world and the ways in which we behave toward each other and pursue our futures. We celebrate this morning all of those members of our diverse religious faiths in America who not only are observing their religious beliefs, but also doing it pursuant to the affirmation of our government in our Constitution, and the very First Amendment to our Constitution that gives them that freedom, a freedom to pursue their religious beliefs without government entanglement and intrusion. Now, beyond that constitutional aspect, let's talk more about what's going to be happening in this, our weekend broadcast here on Amicus. First, we're going to be following up on a lot of the discussion that we had in our first broadcast under the name Amicus just last week. That was our 90th broadcast on the broadcast stations of Civic Media. Today, our 91st, we're going to be following up on some of the significant oral arguments, one of them that happened just this past week in front of the United States Supreme Court. It's one of actually two cases involving reproductive rights and abortion in particular. We're going to spend some time going deeply into exactly what the Supreme Court had in front of it when it came to an argument about the legitimacy of the use of a drug called mifepristone. We've talked about that a lot, and we're going to talk about it more this weekend as we pursue our exploration of what the Supreme Court did just this past week. And then we're going to highlight some things coming up in the coming weeks before the United States Supreme Court. All of these cases, three of them in particular, relate to matters on our political and our commercial and, yes, indeed, our national agenda as we go forward. We're going to talk about a case called Fisher, another case called Trump versus the United States, and another one that we haven't spent a lot of time talking about on our broadcast called Moyle versus the United States. It is an underreported case related, again, to reproductive rights coming up for oral argument in April. We're going to talk about all of those this weekend on our broadcast. And then we're going to go back and do some updates on the two major cases that are pending against Donald Trump. One of them, the hush money case. There is a trial date now before the Manhattan judge, rescheduled just this past week. We're going to talk about what the trial judge did there in resolving the issue of calendaring. And then we're also going to talk about something called a gag order, a term that I do not especially like and embrace because I suspect that it sends a message to many people about something that's not in fact going on. We're going to do some commentary, some case notes, if you will, about that language, and also talk about the order that the judge entered in that case, its propriety under the circumstances, and the reasons why it is significant that that would happen in this particular case and other cases out there. That's the hush money case coming up in New York in just about a couple of weeks from now. Then we're also going to go south and talk once again about the Georgia, also another criminal case, another state case pending in Fulton County, being prosecuted by a district attorney there as well. This one also related to election interference, an omnibus RICO prosecution in that district. We're going to talk about what's going on in that case, and specifically some hearings held by the judge just this past week on motions to dismiss that prosecution offered up by the defendants, and then also what's going on with some appeals of his recent order related to the proposed but not accomplished disqualification of the district attorney. All of that coming up, followed by some review of other cases in the courts of our nation. All of that is coming up on Amicus Law Review this weekend on the broadcast stations of Civic Media.
The Shaw, WAUK, Waukesha's home for Nightlight with Pete Schwaba.
From the kennel to the coop, whatever the season, Fleet Farm has everything to keep your animals happy and healthy. From training your pup to sit season, to mastering those retrieval skills season. From clipping your horse for competition season, to keeping the backyard birds well-fed season. And of course, loving your pets like family season. There's a reason people say, if Fleet Farm doesn't have it, you don't need it. Because we have it all. Fleet Farm, built for real life.
At Civic Media, we encourage active political engagement and remind listeners to think critically about political advertisements you may hear during this critical election year. Our stations are licensed by the FCC and are required to accept all ads for federal candidates. We also air state and local candidates as well as paid ads from issue and PAC groups. Truth is rarely as simple as any political ad may claim. So again, we urge you to think critically about what you hear in the spirit of promoting authentic and respectful civic dialogue.
You're listening to The Shaw.
This is Amicus, a law review, and I am your host for this hour and also next hour on the broadcast stations of Civic Media. Delighted to have you with me and my wonderful producers. Their names, Anya and Abby. We are coming to you this weekend from the broadcast station of Civic Media in downtown Waukesha, but broadcasting once again throughout the state of Wisconsin and beyond. As always, we invite your questions, your comments, your inquiries, your insights to the matters that are on our aggressive but achievable syllabus this morning. That phone number is 855-752-4842. That number one more time is 855 752-4842. I promised at the start of our broadcast this weekend that we would spend some time once again talking about the United States Supreme Court. These 9 members of our highest court in the land, appointed by various presidents upon the advice and consent of the United States Senate. That is also a provision in our United States Congress, and appointed for life. And that means that they do not have to stand for election. They are there as long as they choose to do so. And indeed, some of our justices have remained in those positions for extended periods of time, affecting dramatically the jurisprudence of our nation. This particular court, no exception to that. Clarence Thomas is soon, in a number of years, about to become the longest tenured justice in Supreme Court history. We know that the Supreme Court is presently in its 2023-2024 term. And as we have said previously on this broadcast, right now there are about 62 cases pending before the Supreme Court for decision among the quite literally thousands of cases in which litigants have sought review by the Supreme Court during the course of the past year or so. They chose 62 of those to review, and we have talked about many of those on this, our weekend broadcast. This morning, we're going to go back and we're going to talk more about a few of those cases that are on the docket for oral argument, including one that was argued just this past week. This case again, comes in the wake of the major decision by the United States Supreme Court in June of 2022 to find that under the Constitution, overturning nearly 50 years of tradition and jurisprudence, that the Constitution of the United States no longer, and frankly never did, according to the Constitution, incorporate a privacy right to abortion, to reproductive rights, and sending that issue, as you all well know, back to the states, to legislators, to state courts and other tribunals to make decisions about whether abortion is legal and under what terms and conditions. It was in the wake of that all-important decision called Dobbs, D-O-B-B-S, overturning Roe versus Wade, that many things have happened in our nation that affect, again, dramatically that reproductive right that was previously established for nearly half a century in our nation. And a part of that involves litigation. Along the way, a group of doctors petitioned a federal district court, a trial court in northern Texas, presided over by a judge named Kaczmarek, to find that the drug, the pharmaceutical called mifepristone, had not been properly authorized and approved by the Food and Drug Administration, the FDA. Now, the FDA, over the period of almost a quarter century, about 23 years, has done extensive testing and examination of this drug and determined over the time of those years, involving testing, involving examination, involving practical applications, this one of the 2 major drugs used to accomplish medical abortions in America, found that this drug, mifepristone, is safe and secure. Now, there's no drug in our use in pharmaceutical worlds that is completely without some side effects, and mifepristone is no exception to that. But the FDA, over the course of 23 or so years, determining that it is as safe as any drug can possibly be. Well, these doctors came forward into the federal court there in northern Texas and said, we think that the determination made by the FDA in this particular case to approve and authorize the nationwide use of mifepristone is wrong, that it is not in fact predicated upon medical science, and we're going to challenge that. And indeed, Judge Kaczmarek, in a fairly stunning order, came back and said, I agree with you. He himself, contrary to the FDA's advocacy, contrary to what the Department of Justice was asking him to do, which is to reaffirm the accessibility of mifepristone to Americans in all settings, he found that, in fact, the FDA had not properly exercised its oversight and authority and determined inappropriately that mifepristone was safe. And he did that based upon a few studies that have since, believe it or not, been determined to be unreliable and have been withdrawn by the very people, the very institutions that put those studies forth in the first place. But the judge nonetheless went ahead and did that. The case, of course, appealed to the Fifth Circuit Court of Appeals, The Fifth Circuit, in its review of that lower court order by Judge Kaczmarek, found that while it was not going to embrace the core ruling of Judge Kaczmarek banning mifepristone, nonetheless supported some restrictions on access to it that made it virtually impossible, or very challenging at least, to get the drug. That case now goes up to the Supreme Court. And just this past Monday, as a part of its oral argument process, a majority of the Supreme Court justices appeared to be, yes, that's right, deeply skeptical over efforts to curtail the use of this widely used abortion pill, mifepristone. They called into question whether this group of anti-abortion doctors who had initially brought this case before Judge Kaczmarek, and some organizations along with them, actually even had a right to challenge the FDA approval of the medication. Significantly, some of the important comments from the bench on Tuesday of this past week from justices of the Supreme Court hearing oral argument about whether or not the Fifth Circuit and basically the lower court decision should stand. We have Justice Neil Gorsuch, who described this particular case as an effort by, as he described it, a handful of individuals. He raised the question whether it would stand as a prime example of turning what could be a small lawsuit into a nationwide legislative assembly on FDA rule or any other federal government action. Those are strong words coming from any justice. He was pointedly questioning the attorneys before him and echoing some views of the other justices that suggested that indeed the doctors here did not have standing. They were not able to establish the harm, the danger that would come to them by virtue of the continuation of accessibility of mifepristone. A decision by the justices, of course, anticipated in June, but we know that other justices pretty much align themselves with Justice Gorsuch. And this is one case where the tea leaves, reading from the oral argument of just this past week, indicate that the Supreme Court is likely going to overturn the Fifth Circuit decision. Justice Ketanji Brown Jackson, noting what she described as a mismatch between the anti-abortion doctors claiming they have experience and the remedy they are seeking. Gorsuch, of course, raising the similar point. The doctors asserted that it offends their moral beliefs to care for patients who have taken abortion pills, but asking the court, as Ketanji Brown Jackson said, to impose restrictions on the pill that would dramatically limit its availability for all patients. More of that discussion coming up on Amicus, a Law Review. Stay with us for all of that.
For the Devil's Advocates, weekday afternoons from 4 until 6 on The Shaw, 540 AM and 101.1 FM, WAUK.
CBS News Brief, a warning that terrorists around the world may take inspiration from Tuesday's collapse of the Francis Scott Key Bridge in Baltimore.
U.S. Homeland Security and national security officials are trying to monitor intelligence to make sure that there are not copycat actors or that folks aren't taking lessons learned about the risks that critical infrastructure may be presented with.
CBS national security contributor Sam Vinograd. Final preparations are underway to begin removing the wreckage of the bridge. Pope Francis was a last-minute no-show at last night's Good Friday observances, Vatican officials citing concern for the 87-year-old pontiff's health. And a United flight from Tel Aviv to Newark was diverted to Orange County, New York last night after hitting high winds and severe turbulence. Local emergency official Michael
We
Bigg.
transported 7 to the local hospital for just some observation. No serious injuries or ailments, but most people want to get checked out at the local emergency room.
The flight did originally take off again, but some passengers opted to take the bus. CBS News Brief, I'm Vicki Barker.
Marquette season comes to an end. Hi, I'm Mike Clemens with sports. Men's college basketball. Marquette was favored to win, but lost to NC State 67-58. Head coach Shaka Smart on what's next.
I don't know. We just lost in the Sweet 16. I'm not really focused on legacy. I did tell the guys after the game in the locker room that, our two seniors, Tyler Kolek and Oso Ighodaro, it's been an absolute honor to coach this entire group. The worst thing about losing today is that, we don't have practice tomorrow. We don't have another game to prepare for.
Marquette's Tyler Kolek asked this after the game.
Tyler, how do you balance your individual accomplishments over the last couple of seasons?
I mean, not many people make it to the Sweet 16. I'm just happy to be out there every time with my guys. Like Coach said, I'm just disappointed that it's over.
College hockey, the Wisconsin Badgers men's hockey team losing 3-2 in overtime to the defending national champions, the Quinnipiac Bobcats, who advance in the NCAA tournament. With sports, I'm Mike Clemens.
You can always continue the conversation on social media. Share your thoughts when you find and follow Civic Media on Facebook, X, and Instagram.
With your forecast, I'm Corey Hartman. For today, showers and maybe a thunderstorm, a high near 49. Mostly cloudy tonight with a low around 35. More rain possible on Sunday, cloudy skies, 46. Rain likely Sunday night with a low around 38. For Monday, more rain, breezy, and 46.
Right now, it's 37.
Hi, I'm Emily from Weichert Realtors Lake Point in Madison. Your home, your property, your decision. At Weichert Realtors Lake Point, we'll guide you every step of the way. Whether you're buying or selling a home or exploring commercial property, your dream is within reach. You'll find our realtors love what they do, and more importantly, we think it's fun helping our clients achieve their goals. Who wouldn't want to do that every day? Give me a call at 608-721-8002. Weichert Realtors Lake Point, 2045 Atwood Avenue. Find more info at weichert-lakepoint.com.
Did you know that every day, Preborn's network of clinics experiences 200 miracles? How? Preborn gives women with unplanned pregnancies a window into their womb through free ultrasounds, introducing them to the beautiful life growing inside. Once she meets her child in
One minute out.
Ingram.
So let's talk a little bit about what public education did to move this nation forward and continues to do even though it's under assault.
The one place where we get to live out and practice what it means to be a citizen in a democratic institution. The attacks on public education are really attacks on democracy.
The Earl Ingram Show, weekday mornings 8 to 10 on your local Civic Media radio station and on the app.
Keeping Southeast Wisconsin informed, engaged, and entertained. This is The Shaw. 540 a.m.
This is Amicus, a law review, and you are joining me and my wonderful producer, Anya, here on the broadcast stations of Civic Media. We are talking once again about all things SCOTUS, Supreme Court of the United States of America, specifically reviewing what happened this past week when the 9 members of our Supreme Court heard oral argument, this time for speaking with the justices, having them pepper you with questions about the merits and demerits of your particular case. This past week, the United States Supreme Court hearing oral arguments on this case involving the future of mifepristone in America, following Matthew Kacsmarik's decision way back in 2022 to basically ban the drug based upon his determination, his finding that the FDA had not properly reviewed and approved the drug. The case before the Supreme Court called Food and Drug Administration versus Alliance for Hippocratic Medicine. And we know from the oral argument, reading once again the tea leaves of this oral argument, that virtually every single justice had a problem with this case being brought by the doctors and the organizations with which they affiliated, principally based upon the notion that there was no standing, no damages shown by these doctors, especially in the midst of some questioning by Justice Ketanji Brown Jackson Also involving the Solicitor General, Elizabeth Prelogar, about whether or not the doctors had alternatives, and particularly noting that the rights of the doctors could in fact be satisfied by a right that they already have, and that is a federal conscience protection that allowed the doctors to opt out of providing care they morally object to, adding more steam, if you will, to the argument that there's no standing here. And again, virtually all the justices seem to indicate, led by Neil Gorsuch, but certainly advanced by the others as well, this notion that not only is this case not properly here, but could open the door to tax upon the FDA beyond just this one, arguably prompting other judges down the road to find, based upon their also equally unfounded bases, that a particular drug in some other area of medical administration is not sufficiently been vetted by the FDA. And so along the way, virtually all the members of the Supreme Court expressing great concern about this, suggesting once again that the justices will turn back and say that the Fifth Circuit, the lower court judge, got this wrong, and keeping mifepristone legal in America. In a dissent in another case in 2009, Justice Samuel Alito talked about the importance of the FDA. He was joined in that case by the Chief Justice, his name, of course, John Roberts, and also by Justice Antonin Scalia, alive at the time, a very vibrant and iconic member of the court. He praised the agency's expertise, saying, the FDA has the benefit of the long view. The majority ruled that the agency's approval of a drug had not been displaced by the plaintiff's ability in that case to sue under a state law. The Justice Alito, said, where the FDA determines in accordance with its statutory mandate that a drug is on balance safe, then the court's precedents prohibit any state from countermanding that determination. Again, a suggestion from the Supreme Court justices that they're not going to overturn this, even in the context of access to this very abortion pill, mifepristone. Way back in 2021, the Supreme Court affirmed the authority of the FDA in ruling on reinstating a requirement that women seeking to end their pregnancies use the pill, and that they're required to pick it up in person from a hospital or a medical office. A federal judge in Maryland had blocked that requirement because of the coronavirus pandemic and basically overrode the agency's determination. Chief Justice Roberts, in the context of that case, another case, not the one before the court this past week, but nonetheless on the docket at that time, Chief Justice Roberts was the only person who articulated expressly the reason for supporting the FDA in that case. Said, my view is that courts owe significant deference to the politically accountable entities with the background, competence, and expertise to assess public health. In light of these considerations, I do not see, the Chief Justice said, I do not see a sufficient basis here for the district court, the trial court, to compel the FDA to alter the regimen for medical abortion. All those indications present of just this past week and also historic, based upon previous cases, indicate that in connection with the first case to appear before the Supreme Court in the wake of Dobbs having to do with abortion rights, reproductive rights, the Supreme Court is going to go in the direction of ensuring that access to this drug is available to women and would offer to their partners as well as we go forward and continue to wrestle nationwide with this issue of privacy rights and reproductive rights. The issue, of course, as that last quote indicated, also much tied up in these other issues that we have discussed a lot here on our weekend broadcast, and that is deference to an agency. We know that the Supreme Court also has other cases pending before it in which there are other challenges made by other people under other circumstances to the legitimacy of, for example, the Securities and Exchange Commission, the Consumer Financial Protection Bureau, and again, arguably many other agencies out there. An attack, if you will, upon the expertise, the science, the legitimacy of these agencies that have been operating in our behalf perfectly? No. With imperfection, but nonetheless, based upon their best, not only judgment, but expertise and insight, the science, the facts, all of that also on display in these other challenges before the Supreme Court that are also awaiting decision in June. A major one of them called Loper Bright Enterprises, going to determine whether the fundamental notion of judicial deference to the agencies, that is, deferring to agencies in situations where their interpretations are reasonable, and the law itself, the statutes that are passed by Congress, are themselves ambiguous or in some way not clear. In that case as well, this Loper Bright Enterprises case, Supreme Court has before it a major case having to do with whether or not the Supreme Court and lower federal courts, the appeals courts, the trial courts, will in the future continue to offer up what's called Chevron deference when it comes to understanding and reviewing the decisions of our agencies. This issue, again, in this particular mifepristone case, appears to be a case where the Supreme Court is going to side in favor of the agency. Other cases, unclear. Or at least when it comes to the Loper Bright Enterprises case, a lot of the Supreme Court justices seem to indicate they're willing to overrule the fundamental notion of deference, even if in its applicability to particular cases, they decide in the left way, the right way, the in-between way, all those kinds of things coming up down the road. And in that connection, another case coming up, not yet argued before the Supreme Court, but coming up for oral argument once again before the Supreme Court on April 24th, a case called Moyle versus United States. It is arguably, depending upon how you view this, yet another of these cases in the administrative realm, attacks upon agency decisions, or at least interpretations of the law, and also falling inside the category of reproductive rights, privacy rights. How does this particular case called Moyle, coming up for oral argument again in April next month, how does that come to the Supreme Court? Well, it turns out the Biden administration had issued some guidance in 2022 following the Supreme Court decision in Dobbs, once again finding no privacy right in the Constitution for abortion. In the wake of that decision in Dobbs, the Biden administration issuing basically these regulations, again, administrative rules, interpreting something called the Emergency Medical Treatment and Labor Act, EMTALA, the Emergency Medical Treatment and Labor Act. The interpretation, the rule that was issued by the Biden administration under that law passed by the Congress required that hospitals receiving Medicare funding, in other words, federal funding from the government, have to provide, are obliged to provide necessary stabilizing treatment to pregnant women in emergency situations. That's what the Biden administration, that's what the administrative decision was in 2022. And that interpretation, that rule, if you will, also included emergency abortions. And so once again, the issue before the court, well, it turns out that Idaho and the state legislature there challenged that rule, that administrative decision, and argued in part that the EMTALA, again, once again, this Emergency Medical Treatment and Labor Act, conflicted with an Idaho law, that Idaho law called the Defense of Life Act, the Defense of Life Act. And what did that act do? Well, as the name of the law indicates, it bans abortions in the state. No abortions in the state of Idaho. And it turns out that the lower district court judge, Judge Windmill, in that case, Winmill, issues a ruling in this U.S. District Court in Idaho prohibiting Idaho. Idaho loses this case from enforcing the state law because it conflicted with EMTALA, basically saying under the Supremacy Clause of the Constitution, the federal law applies, the Idaho law prohibiting abortions does not, and the EMTALA is supreme to the lower court, lower state ruling, the lower legislation in this area. U.S. District Court, that then goes up to the Ninth Circuit, and the Ninth Circuit similarly agrees with the lower court, denies a request from the state to put the ruling on hold while the appeal process goes forward. And the United States Supreme Court, again, grants the writ of certiorari, which again is this recommendation, this decision to take the case on as a part of its present term. The court also granted a temporary hold on the district court ruling that required emergency rooms in Idaho to provide abortions in emergency situations. And so time is of the essence, again, in this case as well, all of that being argued before the Supreme Court on April 24th in this case called Moyle versus United States. a second case involving not just abortion, as significant, as important as that is, but also the role of agencies in America, what our Constitution means, what rulemaking means, and the future more generally of privacy rights in America. What other situations like this will be discussed before the Supreme Court on April 24th when it takes up Moyle versus United States, just as it did the case involving mifepristone of this past week. We know as well that there are there are 10 cases altogether pending before the Supreme Court, oral argument in the month of April. Two more in particular that we have talked a lot about on our weekend broadcast. And that is one case involving Fisher versus United States. He is this convicted defendant who is challenging the very statute under which he was convicted, a federal statute that prohibits the corrupt obstruction of government proceedings. He maintains before the lower courts and now before the Supreme Court that the statute does not apply to his conduct, and therefore his conviction, the judgment against him, the criminal judgment against him, entered by the federal district court in D.C., approved, supported by the federal appeals court in the District of Columbia, all of that should be overturned, and the Supreme Court should find that because the statute does not apply to his conduct, therefore his judgment should be vacated or reversed. The reason why Fisher is so important is because that same statute is one of the statutes that Jack Smith has used in prosecuting Donald Trump on the major election interference case that is now pending, not so much in the district court, not so much in the appellate court, but also before the Supreme Court, that having to do with election interference. And the reason why that case is also suspended is because there's a second case also coming up for oral argument in April 25th. That is Trump versus the United States, and you all know what that case is about as well. That's the immunity case. That's the case in which Donald Trump himself, unlike the Fisher case where he is not named as a party, but the result could have an impact upon his prosecution, in Trump versus the United States being heard by the Supreme Court on April 25th, the Supreme Court going to decide whether there is such a thing as presidential executive immunity. As we have said often on this broadcast, a situation where the notion itself is beyond ridiculous, it is frivolous, it cannot be, and we need to anticipate that the Supreme Court, not only when it entertains oral argument on April 25th, but also when it returns a decision in June, that it is unanimous in saying that we do not have kings in our nation, we have presidents, and there is no such thing as immunity. All of that happening before the Supreme Court in the month of April and then in June, when we will continue to cover the work of the Supreme Court here on this broadcast station, here on Amicus, a law review.
Shaw, WAUK, Waukesha's home for Up North News Radio.
For the longest time, it was hard for me to even get out of the house, much less do a backside 180. It took me a bit to understand what was going on, but eventually I learned I had anxiety. Now I'm getting help for it and feeling so much better. Sure, some days are better than others, but the whole thing about getting out of the house, that's not really an issue anymore.
Mental health care is working to see what it can do for you at mentalhealthcareworks.org. A message from the American Psychiatric Association Foundation.
The Todd Alba Show.
I love me some Drew Holiday. My favorite Buck. I love what he's doing. I just really, really wish it wasn't for the Boston Celtics. My loyalty is still more to Giannis. But like when Drew scores a bucket still, I'm like, yeah.
Like to a former lover.
I got a Drew Holiday jersey, a Bucks jersey, and I got an Aaron Jones Packers jersey. So I'm a scoring former lover for both of those players.
The Todd Alba Show, weekdays noon till 2 on your local Civic Media radio station and on the app. The Shaw,
This is Amicus, a law review. My name is Jim Santelle, your host this hour, and yes, next hour as well on our weekend broadcast, where we examine things like the rule of law and justice and government and lots of things having to do with courts in America. in our first segments of this hour, talking about what's happening before the Supreme Court and committing to not only to continue to cover those oral arguments, to get a sense of what our Supreme Court is thinking about these major issues. 62 cases right now pending in front of them. 11 of those cases already decided, including, of course, one case involving Colorado and the decision by the Supreme Court to ensure that Donald Trump remains on the ballot in that case. Another case involving other issues out there having to do with the laws, the statutes of America, many other cases pending before the Supreme Court. And we will continue to monitor all of those cases as we go forward, including some very special broadcasts here in Civic Media in June and July, probably as well, talking about the actual resolutions, the decisions that will be rendered by the United States Supreme Court, most typically late May into June and perhaps even into July. Wouldn't be spending lots and lots of time doing deep dives, doing some of our microscopic justice, if you will, our analysis of those cases as they come out. We also spend time talking about other courts in America, and in this final segment of our first hour, no exception to that rule. We know that just last month, in a civil case, not a criminal case, a civil case pending in the Manhattan courts, a fellow named Arthur Engoron. He is the justice, he is the judge presiding over this major valuations case in which the Attorney General of the state of New York, her name Letitia James, had charged successfully in the end that Donald Trump and others had undervalued, misrepresented the values of various properties of his in violation of New York law, basically premised upon the notion that those violations resulted in losses to the state of New York because of the misstatements, the false statements made, revenues that they would otherwise have gotten if Donald Trump and others had properly valued his properties as a part of his obligation to account properly and to report properly on the actual values of those properties. Justice Arthur Engoron, in this major decision, had found that indeed the government, the state of New York, had established that a $454 million judgment was appropriate, reflecting the interest payments also that Donald Trump owed based upon these false valuations, an amount probably now approaching $500 million. And in addition to that, Justice Engoron had imposed some restrictions on Donald Trump and his family, barring him from running that New York company, obtaining a loan from a New York bank for 3 years, other things there, and applying those also to his adult sons for 2 years. Now, in a move just on Monday of this past week, Donald Trump got a favorable ruling from the appeals court. Donald Trump indicating that he is going to appeal that $454 million judgment entered by Justice Engoron to the appeals court. And he's going to attack it on substantive grounds, going to maintain, presumably, that there was not a sufficient evidentiary basis to make that finding, and that Justice Engoron did other things that erred in the determination of that ultimate judgment there. That will be a part of the substantive appeal. But along the way, in order to what's called perfect that appeal, to be able to accomplish that appeal in the first place, he had to place a bond, basically to ensure that he will pay off that $454 million amount. In a recent court ruling, Trump's lawyers had identified and said to the judge that it's a practical impossibility, and revealed that Donald Trump had gone to more than 30 companies in trying to identify one of them that would give him a sufficient amount of money to support this appeal. Stunningly, at about the same time, Donald Trump also went on social media and said, no, I'm entirely able to do this. I'm very wealthy. I can do just this, completely contrary to what his attorneys were saying in court. Well, as a part of this further litigation by those attorneys, by Donald Trump, they also sought a reduction from the Court of Appeals in the requirement, the amount of the bond that had to be posted. And indeed, just this past week, with the clock ticking, he had 30 days from the time of Justice Engoron entering this judgment before the Attorney General could begin to execute on that amount, basically seizing properties, seizing bank monies. 30 days, the New York Appeals Court handed the former president a lifeline. And on Monday, said that it would accept a far smaller bond of only $175 million, reducing the bond, and not the amount of the judgment, but the bond necessary to perfect that appeal. This ruling by a panel of about 5 appellate judges was really a crucial and pretty much unexpected victory for Donald Trump. It basically staved off a looming financial disaster for him. Had the court denied that request for a smaller bond in this fraud case, which again brought by the attorney general, she was going to go ahead and begin to execute on the total amount of that. And he risked losing control over his bank accounts and even some of his marquee properties right there in Manhattan, other places around the country. And that's what you do when you execute on a bond. What the appeals court said was, in order to protect this appeal, you do not have to post, if you will, through another company. The entire amount of the bond will accept $175 million instead. It's a major decision, a major procedural decision by this appeals court. Now, Donald Trump, from the date of the order reducing that amount of the bond, had 10 days, now about 5 days to secure that bond. Some people with knowledge of his finances indicate that he may, in fact, be able to do that based upon this promise from an outside company that will cover his judgment if he ultimately loses the appeal and cannot pay. And that company apparently agreeing to do this, pledging about $200 million in cash and some other investments as collateral to support the presentation of this $175 million bond. It looks as if sometime this coming week that will happen, and therefore Donald Trump goes ahead and seeks review by the appeals court on the substantive grounds that Judge or Justice Engoron did not properly decide this case. And that appeal then, that will take months, if not years down the road. Lots of things have got to happen, including some initial review by the judges on the appeals court. Lots of other things involving the filing of briefs, perhaps oral arguments as well before that appeals court, before we hear the final word on whether or not this major, almost $500 million judgment in the civil arena should in fact be upheld. We'll continue to monitor all of that, even in the years much ahead. We continue with Amicus, a law review, more on justice, the rule of law, and government in our nation as we continue in our weekend broadcast.
Home of the Earl Ingram Show, weekday mornings from 8 till 10 on The Shaw, 540 AM and 101.1 FM WAUK.
Monday on Matt Nair On Air, we talked to a Wisconsinite who says he will no longer support the former president, and we learn what we can do to help the Monarchs. Join us. Ask yourself, why massage therapy? With benefits like muscle relaxation, improved circulation, tension alleviation, stress reduction, and enhanced mental focus, the answer is simple: investing in your health. Your journey to wellness begins at Fanny's Body Sculpt in New Berlin. They offer a Brazilian lymphatic drain massage to detoxify your body, reduce water inflammation and retention, as well as shape your silhouette. Perfect for prenatal, postpartum, and more. Take the first step to a better you. Call 414-499-6308 today.
You're listening to The Shaw, WAUK 540 AM Jackson, W266DR Waukesha, and always streaming on the Civic Media app.
This is CBS News on the Hour, sponsored by O'Reilly Auto Parts.
I'm Vicki Barker. Massive recovery and repair material converging on the waters around the collapsed Francis Scott Key Bridge in Baltimore. The largest crane on the eastern seaboard is going to be aiding the effort, but it may be months before the port of Baltimore can reopen. Meanwhile, Jim Salmon of the Delaware River Bay Authority says that state is taking steps to protect one of its major bridges. CBS's Stephen Stock has been talking to him. I'm sorry. Let me try Introducing Stephen Stock
The
again.
state is spending $95 million installing up-to-date protections on the Delaware Memorial Bridge.
If a ship would happen to lose control or lose steering and veer towards one of our tower structures, these new Dolphin cells will protect our tower structures. It's what I would call our insurance policy.
That insurance policy with new reinforced structures might have made Tuesday's crash less catastrophic. The changes to the Delaware Memorial Bridge are meant to withstand a collision with the ship heavier and moving faster than the Dolly when it hit the Key Bridge.
Pope Francis was a last-minute no-show at a key Easter ritual last night. He is expected to be able to celebrate Easter Mass tomorrow. Anti-Israel protests in Jordan again today, with demonstrators calling for an end to Israel's attacks in Gaza and the slowdown of aid threatening famine there. This week, Israel announced it would stop working with UNRWA, the UN agency helping Palestinians in Gaza, after some of its workers were implicated in the October 7th massacres in Israel. CBS's Chris Livesay has more.
The UN is investigating the allegations against its staff, which it fired immediately. That's 12 people out of 30,000 throughout the region. And what the director of the West Bank office of UNRWA told me is that there simply is no other organization in the region with either the resources or the personnel to take its place.
And a United flight from Tel Aviv to Newark was diverted to a small New York State airport last night after hitting severe high winds and turbulence. CBS travel editor Peter Greenberg with this reality check.
Flights get diverted all the time. United Airlines, by the end of this month, which is fast approaching, will have had 131,000 departures and only 9 incidents, none of which were life-threatening.
Try telling that to the passengers involved. The flight did resume, but some of them opted to complete their journey by bus. This is CBS News.
Think O'Reilly Auto Parts for all your car care needs. Get the parts and service you need fast from the professional parts people at O'Reilly Auto Parts.
For Civic Media News, I'm Terry Bell. Some people, mainly older Americans with disabilities, are eligible for both Medicare and Medicaid. Outreach efforts are helping eligible people in Wisconsin sign up. Mike Moan reports.
Only about 3 in 10 people who qualify for dual-eligible special needs plans were enrolled in 2021. Experts say the option is designed for people who need additional help because of disabilities, certain health conditions, or their age. Dr. Gina Williams with United Healthcare says these plans try to take a dynamic approach to serving those eligible.
Everything from managing your wellness to managing your behavioral health needs and then everyday needs. So it's kind of a more comprehensive package for people who need a little bit more support.
Those everyday needs she mentioned include meal benefits and bathroom safety devices. Wisconsin's enrollment numbers are similar to the national rate, coming in at 28%. Christine Huberty with the Greater Wisconsin Agency on Aging Resources says a tricky component of these plans is navigating provider network restrictions. A rural resident might have to travel farther to see a doctor covered under the plan, and she says that warrants careful research when enrolling.
I would say first and foremost, look at the provider network restrictions and look at what's available in your area.
Meanwhile, Williams says the push to get more eligible people to sign up coincides with more awareness about preventative care in a post-pandemic world.
They're not only thinking about acute illness, but they're thinking about overall care. Like, what was the impact of the pandemic from a psychological standpoint? Do you need more support? And then do you also need more coordination of benefits?
This is Mike Moen for Wisconsin News Connection.
You're listening to Civic Media News. I'm Terry Bell.
Monday on Nightlight, On Stage for Cancer performs live, and I'm joined by filmmaker Mark Garvey. It's Nightlight from 7 to 9 p.m. on the Civic Media Radio Network.
With your forecast, I'm Corey Hartman. For today, showers and maybe a thunderstorm, a high near 49. Mostly cloudy tonight with a low around 35. More rain possible on Sunday, cloudy skies, 46. Rain likely Sunday night with a low around 38. For Monday, more rain, breezy, and 46.
Right now, it's 37.
Waukesha, home of Les Paul, our awesome farmers market, and the Shaw. 540 AM.
Welcome to our weekend broadcast. My name is Jim Santelle, and yes, this is Amicus, a law review, our weekly examination of major events in our state, our nation, and our world, having to do with law, government, courts, and the delivery, the aspiration for justice in our land and beyond. This hour, as last hour, talking again about courts in America. In the end of our first hour on this broadcast, talking a lot about this decision by the appeals court in New York to reduce the amount that Donald Trump is required to place as a bond as he appeals the nearly $500 million judgment entered against him by the New York court based upon the valuations case against him. I've always promised in the past that we do a little bit more analysis of those kinds of things under a heading called Law Review Case Notes, and this is where we're going to begin that process. Important to understand what is going on here. Yes, indeed, the appeals court does have the authority, the responsibility, if you will, to decide on petitions like this one to reduce a bond. But what are the other tea leaves that we read from this? Well, you look at that and you think, gee, if there's an appeals court that is already somewhat receptive to the Donald Trump petitions, although they're not ruling directly on the merits, the substance of the appeal itself, this ruling in which they reduce dramatically, significantly the amount of bond suggests that some of those judges, some of the 5 appellate judges on the New York Appellate Court, some of them could be very sympathetic to Donald Trump's case. And in fact, more suggestions of that come in connection with the other things that they did that have sort of run under the radar on this. As I said before, Justice Engoron, in addition to imposing this huge judgment on Donald Trump, also imposed some restrictions on him and his family. He barred him from running a New York company, obtaining a loan from a New York bank for about 3 years, and those same restrictions also applied to his adult sons. Significantly, Justice Engoron also extended the appointment of an independent monitor who is this really watchful outsider to keep an eye on the family business, to get authorizations for any major actions through the monitor before those can be done. All of that a part of Justice Engoron's judgment in this case. In addition to reducing the bond, the appeals court also put on hold virtually all of those restrictions as well. All of those restrictions also imposed by Justice Engoron, suspended and put in abeyance, if you will, until the full appeal is heard. The only part of that order that the court endorsed and kept in place was the presence and the work of this outsider, the monitor that is keeping the eye once again on the family business, determining what kinds of transactions can and cannot be pursued. All of that to suggest, from the perspective of people who know a lot about Donald Trump's finances, and generally from perspectives of people who follow appeals and how these things work, that indeed the appeals court may be very sympathetic to ultimately reducing the amount of the overall judgment when it comes to the merits, the actual wrestling with the legitimacy of the judgment itself. It will be months, it may be years before we see what the appeals court does. And we don't know for sure if the 5 appellate court judges who made this decision to reduce the bond and also take away these other limitations on Donald Trump and his sons and the company generally, we don't know if those are going to be the same judges who decide the actual appeal. But it certainly indicates that inside the Court of Appeals, there is certainly some sympathy, some attraction, if you will, to Donald Trump's position that the $454 million judgment, actually now much more in excess of that, should be reduced in some way. Time will tell and the process itself involving, again, the filing of briefs, oral arguments to the appeals court, all of that will result ultimately in a decision. We anticipate probably this coming week that Donald Trump, through his Savior Company, will post the $175 million bond and effectively perfect and accomplish that appeal to the Court of Appeals. We'll continue to monitor that issue here on Amicus, a law review, as always. And as always, taking your phone calls. Anya and I are at 855-752-4842. That number, once again, 855-752-4842. Before we go on to other things happening in courts, state courts in our nation, we're delighted to have callers, as always. And Joe, calling in from Madison, thrilled to have you with us this morning as well.
Thanks, Jim. I appreciate all the detail and the scrupulousness in which you present this. It's very helpful. I wanted to ask your thoughts and reflections, and I'll hang up after my question. And it does have to do with this court case that you're speaking of now, in which the bond has been reduced for Trump by hundreds of millions of dollars prior to what he was told that he had to arrive at. You would speak of the fact that this appellate court may be sympathetic to Donald Trump, yet there's nothing indicating why they would need that sympathy. For example, somebody suggested, well, these cases are complicated. Thus, it's how he extracts the money out of his various investments is difficult, and so maybe they were sympathetic for that reason. I think the problem is for average citizen, they look at that and they think, people I know who were in trouble and had to post bond got no break at all on what they were doing. They were told, this is your bond, do it. And, no argument. You can't just argue it away or go appeal it. And it's this interesting thing in terms of two-tier justice and in terms of how it looks. And because the appeals court offered no reasons for why they dropped this dramatically, and I understand, it's not done yet and there's more in the future, but it still has the appearance, I think, for the average person of, gee, nice deal. I guess it pays to be rich, words to that effect. Can you just offer your thoughts on this? And I mean, my concern is that there's an erosion for the respect of the court if people know, well, rich people are just going to get away with it.
And Joe, appreciate the comment and the question, the inquiry, with which I concur. It is about the appearance. We talk a lot about that on this broadcast. And although, yes, this can be viewed as sort of an interim decision, reducing this bond, as you indicate, Joe, is it important? You bet it is. It's hugely significant in the overall management of this case. And I would concur entirely in this area and in other areas we'll talk about a little bit later in this hour, that Donald Trump gets some consideration that certainly is not available to an awful lot of other people who are out there who likewise, whether they're seeking to pursue something on appeal, seeking reductions in their bond, and oh, by the way, even saying things outside of court about the pendency of their cases, their trials. We're going to talk about these orders being entered by trial court judges as well, trying to restrict him. All these kinds of things where Donald Trump does and says things that others based upon wealth, based upon status, based upon notoriety, do not get the benefit of. And that's the problem, Joe, as you just identified, for the perception of a court that gives people who have some wealth, who have some status, have some notoriety, considerations that in the state of Wisconsin, in the state courts, even the appellate courts, in the federal courts here in Wisconsin and throughout the nation, normally people do not get this kind of consideration. I agree with you. And while we'll have to read the tea leaves as the appeals court goes forward and manages this case even more, the notion that they might be signaling already some concern about the underlying case and the legitimacy of Justice Engoron's judgment is also concerning. Those are the kinds of things that you wait for an appeals court to decide, pursue on oral argument, pursue in the course of their orders themselves. All of this sends some signals that again, I think, as do you as well, I suspect other listeners similarly feel the same way, that while it is unusual, admittedly, to have a $500 million judgment entered against you, very few of us, if any of us beyond Donald Trump, have that particular experience. It is in the interest of equity and equitable justice and the delivery of justice that prompts us to think, gee, would I get that same consideration if I was in a like, if not exactly the same situation? The concern is legitimate, and courts need to be attentive to that. We talk a lot about the Supreme Court's present reputation. They need to be concerned, first and foremost, of course, about the law and the application of the facts to it, but also need to be perceptive of the world in which they live. And Joe, your comments about this erosion in the perception of what judges are doing in America, it is a consideration for all of us as we think about how we elect judges, who we elect to those positions, what judges are also appointed in the federal system as well. All of that a reason to be focused on the judiciary in ways that perhaps we have not done in years past. Joe, thank you so much for the comment. As always, insightful and important. Bill, also calling in this morning. Bill, appreciate your question or your inquiry this morning on Amicus, a law review.
Great topic. My question is this. Do you not think that Trump's attorneys are now, besides him, are held to a level of accountability? Because if you bring in a criminal and he just perjures himself and makes false statements, how much does this have on their attorneys and their commitment to their bar and the standards they held up? I'll hang up. I want your opinion.
Terrific insight once again, Bill. Thank you for calling in. Appreciate this. And again, anticipating some more discussions here. Perhaps I can simply say at this point that yes, the integrity of the attorneys who appear in front of courts and judges is always at the top of the list. I always say that lawyers have two things. We have words, both written and also oral, and we've got integrity. And you take away either one of those, you no longer have lawyers, right? Judges look to attorneys to be straightforward with them, to be factual, to provide them with the truth, even if that truth is not necessarily supportive of their client's position. That's what's called being an officer of the court. Every single time I appear in front of court, a criminal court, a civil court, I am an officer of the court, and the ethics rules require that regardless of my advocacy for my client, and again, the ethics rules contemplate vigorous advocacy, even sometimes aggressive advocacy, I can never depart from the facts. I should not be representing to the judge or judges at the trial court level, appellate court level, things that are not true. When I do that, I not only run afoul of the basic ethic rules, but I also violate my oath to the court itself to be an officer of the court. We're going to spend some time talking about what one does when you've got a client like this, as you just indicated, who does engage in activities that brings the reputation of their lawyers along for the ride and arguably contemplates its diminution as well. We're going to do all of that as our discussion here on Amicus, a law review, continues.
You're listening to The Shaw, WAUK, Waukesha's home for the Tom Albaugh Show.
As you age, you may have questions about finding transportation, healthy meals, or other services around your home and in your community. And the Elder Care Locator has the answers at 1-800-677-1116. Our caring advisors can connect you to trustworthy local experts and the support you need to age well at home. Real people, real assistance, and real connections are just a phone call away with the Elder Care Locator. 1-800-677-1116.
Nightlight with Pete Schwaba.
This is National Let's Laugh Day. I think laughter is truly the best medicine. What makes you laugh the hardest? My family members, my kids are funny. My dad makes me laugh. My wife makes me laugh. Conrad makes me laugh. I think one of the most important things that we can do in life is laugh. Personally, comedy's gotten me through some very tough times. It's great therapy.
Nightlight with Pete Schwaba. Weeknights 7 till 9 on your local Civic Media radio station and on the Civic Media app. This is The Shaw.
This is Amicus, a law review. My name is Jim Santelle. Bill has called in and raised this very important issue about the connection between attorneys and their clients and the kinds of things that attorneys are obliged to do when they are officers of the court, appearing in front of a judge. Aggressive advocacy, important advocacy on behalf of their clients, but cannot cross the line. And we have seen, as we will see again later in this hour of our broadcast, what happens when attorneys violate that fundamental principle. But Bill, there is also some illustration of exactly what you described coming out of yet another court, this one also in Manhattan, just this past week as well. We know that the trial of Donald Trump for the so-called hush money case, that's the case brought by Alvin Bragg, the district attorney, alleging that Donald Trump violated New York law in a criminal manner. This is a criminal case when he paid so-called hush money to Stormy Daniels to keep quiet on the affair that he maintains never happened. She says it did. As a part of his effort to try to keep us from knowing about that, as I've said before, this matter, although it sounds fairly limited in its scope, is actually yet another case in the broad category of election interference, an attempt to try to undermine the election, this time of 2016. Why? Because he's trying to undermine the legitimate information that is in the public domain for people to decide upon in making their votes. What happened just this past week in this trial court presided over by Juan Merchan, Merchan. We know that the case was scheduled to go to trial about a week or so ago. It did not do that when it turned out that about 100,000 more documents had surfaced from the U.S. Attorney's Office in the Southern District of New York, produced by Alvin Bragg and given over to the defense as appropriately one has to do during the course of these criminal prosecutions. The judge, feeling obliged to permit Donald Trump, appropriately delayed the start of the trial and then had a hearing just this past Monday on what to do next. And two important things came out of that hearing on Monday about the scheduling of the trial, but also about other things having to do with the behavior of lawyers and also Donald Trump, going right back to what Bill has raised. We know that Judge Merchan, in this case, again, before him is a request by Donald Trump for a 90-day delay for the purpose of reviewing these additional documents before the trial can be resumed here. After a mid-morning break where the judge had talked to the attorneys about all this, trying to figure out what had happened, the judge came back and said fairly summarily, the defendant has been given a reasonable amount of time and rescheduled the trial to begin on April 15th, about 2 weeks from now. Doesn't give the defense a huge amount of time. That, of course, in his discretion based upon what he has heard from the attorneys during the course of this presentation before him just this past week. Along the way, following up on Bill's comments, the judge said this. He said the defense's allegations that prosecutors had made ethical errors related to the disclosure of these documents were, and these are the judge's words, were incredibly serious, unbelievably serious, he said, and then he scolded Trump's lawyers for failing to substantiate their claims. A classic situation, Bill, where the judge identified lawyers appearing in front of him making allegations, making statements that were not in fact supported by the record. The judge went on to say this in admonishing these attorneys. He said, "You are literally accusing the Manhattan DA's office and the people assigned to this case of prosecutorial misconduct." That's no small thing. "And trying to make me," meaning the judge, "complicit in it." Those are strong words coming from any trial judge who's presiding over a case like this, admonishing the lawyers to behave, to tell them that when it comes to representations, even by a client who would like them, I'm sure, to lie and to misrepresent, that is not their role as officers of the court, and arguably setting themselves up for some review by a licensing authority. Exactly the kind of thing that Bill is talking about as Judge Merchan, number one, sets this case for a trial, dismissing the unfounded allegations of misconduct, finding the defense has enough time to review these documents, and planning for jury selection, which itself will take a couple of weeks on April 15th, which of course is also tax day. Now, something else happened. Something else happened during the course of this past week in the wake of that hearing, but also coming from the pen of Judge Juan Merchan, that also goes to this issue that Bill raises about the behavior of a client and the relationship with attorneys. The New York judge, again, presiding over this same criminal trial, imposed what's called, again, I always balk at this, a gag order. Did this on Tuesday. This is Juan Merchan. And let's talk for a minute about the language of these orders themselves. The media talks about these as gag orders, and they are not. To gag someone means quite literally to stop them from talking, perhaps in the most literal sense to putting a Band-Aid or some other restraint on their mouths. That's not what's going on in any of these cases. And so I always balk at and try to describe these in situations where judges look at circumstances and impose reasonable restrictions upon not only the defendant in front of them, but also upon any defendant who appears in the courts, the criminal courts of our state and of our federal government as well. There is a requirement by anyone who appears in a federal or state court to abide by the basic rules and conditions of that. And along the way, one of the things you cannot do, whether you are a state defendant, a federal defendant, either as a lawyer or as a defendant, the person who's on trial, himself or herself, you cannot be out there affecting the course of the very trial in which you are the defendant. And that means you cannot threaten witnesses. You cannot suggest that people threaten them on your behalf. You cannot in some way affect the jury pool by suggesting that the evidence in the course of the trial is going to be wildly tainted. That's the product of fraud or false representations or some sort of forensic misconduct by the prosecutors. You cannot attack the people who are a part of the justice system themselves. And I offer that that includes the judges, their staff, the prosecutors, their staff, defense counsel, their staff, all the court personnel who are responsible for calling in jurors. It certainly includes the people who are those jurors and those witnesses, but it includes everyone who is responsible for delivering justice. And we know that this issue about Donald Trump being out there and saying things that tend to suggest the trial is not legitimate, that people are lying, that he has been the victim of offensive behavior by judges who are described in very colorful terms by him, attacking the prosecutors, sometimes attacking other participants, including court staff. All of that is inappropriate. And so judges, when they're presiding over these cases, are required to administer their cases in such a way to protect the ultimate legitimacy of the judgment that's going to be rendered by a jury. And so we see these so-called gag orders, again, not the word that I would use. I would call them orders that simply establish order in their courts, imposed upon Donald Trump, again, this past week in the case pending before Judge Merchan, also imposed previously by Judge Tanya Chutkan in that federal case in Washington, D.C. More of this discussion about these kinds of orders coming up and exactly what Judge Merchan did this past week to preserve justice in the trial now going ahead in his Manhattan courtroom in the middle of April.
Whether you're heading down Les Paul Parkway or fighting traffic on the interstates, this is The Shaw, 540 AM and 101.1 FM, WAUK.
CBS News Brief. Heavy equipment is moving into place in the port of Baltimore to remove debris after the Key Bridge collapse. Este Pinchazin is commander of the U.S. Army Corps of Engineers.
By investing this time now in the engineering, we're going to be able to move faster later. And I know right now, everyone wants to see things moving. You need to know, you need to trust that behind the scenes it's moving.
Pope Francis skipped a popular Good Friday procession of the cross in Rome. Here's CBS's Jeff Glor.
The Vatican says he skipped the traditional Good Friday procession to preserve his health ahead of Easter. He is expected to preside at an Easter Vigil service today and celebrate Easter Mass tomorrow.
Spring storms are hitting parts of the West Coast. Weather Channel meteorologist Kelly Cass.
Some spots could see perhaps 3 to 5 inches of rain. And then, of course, you've got the snow that's going to be piling up across the High Sierra. We have had quite a busy winter season on the West Coast.
CBS News Brief, I'm Wendy Gillette.
Enjoying this local program? Find the complete Civic Media lineup at civicmedia.us or the Civic Media app.
The Brewers battle the Mets. Hi, I'm Mike Clemens with sports. It was the first game of the season, and already tempers flared between the Brewers and Mets in New York after Milwaukee's Rhys Hoskins slid hard into second base. Coverage on the Mets TV network.
A tough pickup from McNeil. Are they going to call the out? They are. And then an overslide at second base by Hoskins. And we have some hard feelings as Hoskins has words. Both benches have emptied. The bullpens are joining it as well.
No punches were thrown. Milwaukee went on to win the game 3-1. Brewers manager Pat Murphy.
That shows what Rhys is about. He's a big league ball player. He's sending the message that even when you're not having the day you like at the plate, I'm going to play hard.
The series wraps up this weekend, followed by the Brewers home opener on Tuesday. College basketball, Marquette's season came to a close after losing to NC State 67-58 in the NCAA's men's tournament. The Golden Eagles finished with a record of 27-10. With sports, I'm Mike Clemens.
With your forecast, I'm Corey Hartman. For today, showers and maybe a thunderstorm, a high near 49, mostly cloudy tonight with a low around 35. More rain possible on Sunday, cloudy skies, 46. Rain likely Sunday night with a low around 38. For Monday, more rain, breezy, and 46.
Right now, it's 37.
Covering all the news that affects you with humor and a unique perspective. Matinaire on Air with Jane Matinaire. Weekdays 10 till noon on the Shaw, 101.1 FM and 540 AM WAUK, and on the Civic Media app.
Are record energy costs putting a squeeze on your fixed or limited incomes? With inflation rising at record levels and incomes not keeping pace, you might be one of tens of thousands of Wisconsin residents who are struggling to survive in the blistering heat of summer or the bitter cold of winter. While you haven't asked for it, the Keep Wisconsin Warm Cool Fund and your local energy assistance providers are here to help. No Wisconsin resident should ever have to face the challenge of living without heat or power or face homelessness. For a hand up, apply today and call 1-800-506-5596. That's 800-506-5596. Or visit www.heat.help.
Save big money now at Menards. Menards has the best in-stock selection of AC2 pressure-treated decking and lumber. AC2 pressure-treated thick decking is 15% thicker than standard 1-inch decking, providing a stronger, more durable deck surface. Plus, get free estimates fast, in-store, or online with our deck design programs. And conveniently pick up your materials in our drive-through lumber yard. Head into Menards and get started on your deck project today.
Save big money at Menards.
You are listening to your local Civic Media radio station on air. Thank you. Did you know we are always streaming on TuneIn and the Civic Media app too? And if you miss a show or game, find it wherever you get your podcasts or on our website, civicmedia.us.
Broadcasting to Waukesha at 101.1 FM. Broadcasting to Southeast Wisconsin at 540
This is Amicus, the Law Review. My name is Jim Santelle. Thank you for staying with me this hour as we talk about orders entered by judges to attempt as best they can to preserve the integrity of proceedings going on. Judge Juan Merchan scheduling an April 15th trial date for the so-called hush money or catch and kill case, now scheduled to go to trial on that date in a Manhattan criminal courtroom. And along the way, in the wake of his scheduling that trial to begin in mid-April, also entering an order on Tuesday that prohibits Donald Trump from attacking witnesses and jurors. The latest effort, if you will, to try to rein in the former president's rhetoric about his legal opponents and people who are involved in the justice system. Under the judge's order, Donald Trump cannot make or direct others to make statements about witnesses' roles in the case. He's also barred from commenting on prosecutors, court staff, and their relatives if he intends to interfere with their work on the case. Any comments whatsoever about jurors are banned as well. And the judge cites an array of hostile remarks that Donald Trump had made about grand jurors, prosecutors, and others. There's a notable exception to this so-called order that limits the amount of colorful language that Donald Trump can use. Trump is not prohibited from attacking Alvin Bragg himself, who has received numerous death threats, of course, as you know, in recent months. Bragg voluntarily carved himself out of his request to the judge to enter this order. In other Trump cases, prosecutors are also left out of those gag orders. This particular order, entered by Judge Merchan, he was very closely to the terms of another order that I made reference to. That is the one that has recently been upheld by a federal appeals court in Washington. That was the one that was entered by Tanya Chutkan in the election, the federal election interference trial, now suspended while the Supreme Court decides on the immunity issues. Along the way, the federal appeals court in that case said Trump's documented pattern of speech and its demonstrated real-time, real-world consequences pose a significant and imminent threat. And indeed, we know a lot about this, the kinds of things that Judge Merchan, the Tanya Chutkan, indeed Justice Engoron also wrestled with when it comes to the kinds of things that Donald Trump inappropriately says about virtually everybody involved in the criminal justice system. Trump previously has taken aim at Michael Cohen, of course, who's going to be one of the principal fact witnesses in this case, one-time fixer, his lawyer at one point, and he's called him a liar. He's called him a rat. Instead of a rambling and a fairly angry post on social media just this past week, Trump made an ominous reference to Michael Cohen, claiming without some explanation, some clarity on this, that his former lawyer was deaf. He also referred to one of Mr. Bragg's prosecutors in pejorative terms. And all of that comes in the midst of the defendants also posting on social media some references to the judge's own daughter. Those also much bandied about in the national media these days, which raises the issue about what will happen when the judge, again, reconvenes this coming week. Trump has also called other judges, including Justice Engoron, again, in the valuation case, called him a nut job. He's targeted prosecutors in virtually all of his criminal cases. He's accused them of falsely working in concert with President Biden. And he's called the DA himself a racist. All of that as a part of the overall record that Judge Merchan looks at and says, we cannot be having this. And so imposes this limited order that first and foremost is intended, once again, to ensure that witnesses and jurors and court staff and everybody else affiliated with the delivery of justice in this case, whatever it may be, are not the targets and are not affected by this kind of thing. As I said before, it is the expectation of every other criminal defendant in America, in every state prosecution and any federal prosecution. There is nothing special about restrictions at all being placed upon Donald Trump. And that's part of my objection to this, that we need to enter a special order or a series of orders, as Judge Chutkan has done, as Justice Engoron has done, as Judge Merchan has done, to establish what is known out there. This behavior is inappropriate. It is contrary to the rule of law and cannot be tolerated. The question then, of course, is just this. What does Judge Merchan do as we go forward here? It is also significant to note, as the justices and judges have done when they've reviewed these cases in the past, to find that this is not a violation of Donald Trump's First Amendment rights. He can, in fact, get out there and say that he is not guilty of the offense conduct. He can maintain that the facts will show that he cannot be found guilty beyond a reasonable doubt by a unanimous jury. He can make those general comments. What he cannot do is talk about the individual defendants, individual witnesses. He cannot talk about co-defendants either. He should not be talking about jurors and all those kinds of things that would potentially infect the very process. That's what these orders prevent him from doing. And again, they're simply articulations of orders. not violated not prohibited at all by the First Amendment. These are things that are assumed to be the regular conduct of every defendant who is out there in our criminal courts these days. The reference to gag orders, once again, no one is being gagged here. Donald Trump can, in fact, speak, and he can talk during the course of his own campaign about issues that are important to him in the pursuit of the presidency. None of that restricted by any of these orders entered now by Judge Merchan, Judge Engoron, and also by Judge Chutkan. None of that prohibited in the political domain. Things related to the trials themselves, absolutely. And once again, not violative of the First Amendment, no free speech violations here at all, and attempts by the judges to ensure that the integrity of the system is established. It is also important to note that at some point, as Bill and others have indicated, that the attorneys also have some responsibility here. The judge's recent order protecting prospective jurors in the case effectively also barred Trump from exposing their entities, emphasizing the need to protect those who might decide this highly, highly important case. He also ordered that their addresses be kept secret from everyone except the lawyers in the case. And it's in that context that Bill's comment, again, is very significant. In an unrelated order on Tuesday, the same time, Judge Merchan issued a stern warning to the Trump lawyers as well. He reminded them to behave professionally or risk being held in contempt. Here is what he said. Here is what Judge Merchan said to the lawyers in that case. He said, "This court emphasizes that it hopes for and fully expects zealous advocacy from counsel, as well as spirited contribution from witnesses and parties alike." That's Judge Merchan writing in this case. He goes on to say this, however. Nonetheless, the court expects that the line between zealous advocacy and willful disregard of its orders will not be crossed. That's the point that Bill was making before about the involvement of attorneys to enforce what the judges are saying, and also their own obligations as officers of the court to follow those very, not restrictions, but simply guide rails to ensure that the legitimacy of the trial is protected going forward. The all-important question, not only in the case pending before Judge Tanya Chutkan, the case that's now concluded in front of Judge Engoron, in which he did in fact fine Donald Trump several $1,000s for violating the orders, not limiting but imposing legitimate restrictions on him. That case, and now this one, the question is, what does Judge Merchan do in the coming week and weeks going forward? There is the argument already made that Donald Trump has already violated the very terms and conditions of the order imposed just this past week. What are the remedies available to Judge Merchan going forward here? One of them, again, is fines. He can certainly impose monetary fines against the defendant, including fines against counsel if they likewise violate these rules. And yes, indeed, if indeed the nature of the violation of these orders is significant enough, there can be a finding of contempt. And depending upon the nature of the contempt, there's criminal contempt, there's civil contempt. One of the remedies available to a judge is imprisonment, is jailing. And one can purge oneself of that contempt by promising to behave, to be good, if you will, in the language of grade schoolers. But that is one of the remedies that is out there. And we will see what Judge Merchan does in the coming days, even in the wake of the things that Donald Trump has said about the judge's daughter, about other people involved in this case, arguably violative of the order entered by Judge Merchan just this past week. Important comments made by Bill, important comments made by other callers, including Dick, who's calling in from Madison. Dick, appreciate your inquiry here today as well.
Well, this is off topic, I know, but you know how we would not be talking about this man whatsoever? In the 60s, during the Civil Rights Movement, I think we fumbled the ball when we didn't go all the way and go after the Electoral College. That you talk about not getting the courts we like or we deserve. How about not even getting the candidate elected that we elected? He lost by over 3 million votes to Hillary Clinton. And this nonsense that you have, this archaic thing on the books yet, the It just drives me crazy. The civil rights movement should have dealt with it in the 60s. And everybody keeps telling me, oh, this can never happen, Dick. Why not? The Republicans went after Roe v. Wade. Now I realize I'll probably never live to see what I'd like to see, where one person, one vote. But I don't know why somebody doesn't address it at some point, because the guy would be totally irrelevant. We wouldn't even be discussing him.
Dick, points very well made. A couple of thoughts on that, very much in support of your observations. One is, yes, it was put into our Constitution by James Madison and George Mason and other people. It is a part of our Constitution. So to remedy this, we need a constitutional amendment. Can that be done, Dick? Sure it can. Sure it can. Need passage by both houses of Congress. You need the states to ratify it. And we can remove the Electoral College by a constitutional amendment. I know that you and others, and I included, will talk about how difficult that may be in this present environment. There's a process for doing it. And I agree with you that the whole concept has become anachronistic. It was put in place at a time, again, when we did not have a nation of 330 million people populating states across the country. And again, this notion of one man and one woman, one person, one vote, that's been implicit in the decisions of our Supreme Court, of other judges throughout our history. And that includes, of course, the civil rights history to which you make reference. So I concur in your view that we are getting results here, not just in the recent 2016 election, but in other elections as well, in which the Electoral College delivers a presidency that is not consistent with the overall vote of Americans. Advocacy continues, and Dick, the way you do that is continue to speak out about that on this broadcast and certainly in the community generally. There may come a time in American history when we tire of this anachronistic mechanism inside the Electoral College. We know well there are arguments to keep it in place. The time has come, I agree with you, Dick, to move on and do the one person, one vote approach that contemplates a vote in November and the swearing in January of a candidate who's gotten the majority votes from all Americans in our nation. We've been talking a lot this morning about what's going on in Manhattan, these two cases pending in a civil court and a criminal court. We're going to spend some time also in our remaining moments in our weekend broadcast talking about what's going on in Georgia. We're going to go south here for a while. You may recall that this is the case, this is the RICO case brought by Fani Willis through two grand juries that indict Donald Trump and 19 defendants altogether. 4 of them have already pled guilty to various counts under this RICO, this omnibus sweeping indictment, alleging that they engaged in election interference in the state of Georgia that undermined, that robbed Georgia voters of the opportunity to elect the candidate, to send electors in that electoral college to Washington in the way that they intended to do. Now, in the end, their efforts were not successful, as we know. And so Georgia's electoral votes do, in fact, reflect the fact that Joe Biden won Georgia. But Fani Willis, in that case, brought this omnibus indictment against Donald Trump and others, alleging their interference. And we're going to continue to talk about what happened just this past week in that case, now pending in front of a state court judge there in Fulton County, as we discuss further the processes and procedures of criminal prosecution in the courts of America.
To the Shaw, WAUK, Waukesha's home for the Devil's Advocates radio show.
Keeping you informed, entertained, and connected to your local community. Here's Terry Barr with the Civic Media Radio Network.
Did you know there's a group focusing on the importance of the arts in Wisconsin? Creative Wisconsin is a nonprofit based in Madison and trying to expand thinking about the arts and the economy.
Everybody wants their community to be vibrant and healthy and have people visit and live there. And so we try to help people figure out what they need, and then we figure out how we can help them.
Ann Katz is the director of Create Wisconsin, and she says the work really took off when the group learned the Badger State is in last place when it comes to arts funding and support.
It's an investment in people, businesses, organizations, and communities. People are really hungry for that authentic, unique. That's what we try to nurture and to assist.
Learn more about Create Wisconsin and some upcoming events where you can get involved. Go to createwisconsin.org. Until next time, I'm Terry Barr.
You're listening to The Shaw.
This is Amicus, a law review. Thank you for joining me in our discussion of all things courts. Lots of things going on in the course of our nation, including a criminal court in Fulton County, Georgia, presided over by Judge Scott McAfee of the Fulton County Superior Court. He did a couple of things this past week that also have an impact upon that criminal prosecution, that state RICO criminal prosecution against Donald Trump and many others. First, we know that in previous weeks, the judge has entered some orders, most notably an order dismissing 6 of the counts in that indictment, alleging that the grand jury and the prosecutor had failed to provide sufficient notice, sufficient information to justify those counts going forward. And he'd also found in another, even much more notorious and famous ruling there, that there was no actual conflict of interest in permitting Fani Willis to continue to prosecute the case. He did, however, find that a romance that she had with one of her top prosecutors in that case created an appearance of impropriety, justifying, therefore, that top prosecutor leave the prosecution team, which he did do. That was his order entered fairly recently to the attention of virtually all of American media and all of you as well. Well, just this past week, Donald Trump noticed his appeal of that particular order, calling the Atlanta prosecutor Fani Willis utterly unrepentant. Lawyers for Donald Trump and 8 of the co-defendants, and they're along for the ride on this as well, in this Georgia election interference case, have now asked an appeals court to reverse the judge's ruling that allowed her to stay on the case. And that is significant because once again, we've got another appeal of a pretrial order, this one again in Georgia. And the question is, will that prevent the case from going forward? Well, we know that the judge in that case, Scott McAfee, has already issued a certificate basically of entitlement, a certificate of authorization to permit that appeal to go forward. And along the way, he did say that he has given permission for the defendants to pursue that appeal. But under Georgia law, the co-defendants have to also secure the approval of the appeals court. The appeals court has got to say, much like the Supreme Court does, that they're going to take the case before the matter can be heard by a panel of presumably 3 appellate judges there in Georgia. The appeals court has 45 days to decide whether to grant or deny the appeal application that's now been filed just this past week. And again, the question is whether or not that will hold, and the appeals court will basically put on hold what is going on in front of Judge McAfee. Highly unlikely that would happen, because Judge McAfee is also entertaining at the same time pretrial motions, and he has had a hearing just this past week on the pretrial motions submitted by the defendants in this case, seeking to dismiss the case entirely. First court hearing since this fairly significant ruling, finding that Fulton County DA Fani Willis can remain on the case, and the hearing, again, focusing upon these motions filed by the defense challenging the indictment generally. Trump lawyer Stephen Sadow said that the majority of the overt acts set forth in the indictment involve false statements or tweets which are clearly political speech. And he indicated that all of these things are protected by the First Amendment. He argued, that as the attorney for Donald Trump, that Trump's claims of election fraud, and even his efforts to contact election officials were amid this fake elector scheme, merits protection under the First Amendment. They should not be the subjects of criminal prosecution, but are protected by the First Amendment. He called the conduct of Donald Trump in this particular case, as alleged in the indictment, the zenith of protected speech. Once again, raising this notion that Donald Trump, in this case, for the things that he has said, should not be the subject of criminal prosecution, but protected by the First Amendment. He said, the attorney said, what do we have here? We have election speech. He argued that Trump's statements weren't, as alleged in the indictment, to steal the election in an unlawful fashion, but instead was a public service as a part of his office. Those were the arguments made by the attorneys for Donald Trump just this past week. Some of the expressions on Judge McAfee's face, although he did not rule on the motions this past week, indicated that he was skeptical of those positions and indeed probably going to come down on the side of the prosecutors now continuing to prosecute this case. And among them is Senior District Attorney Donald Wakeford, plainly unpersuaded by the arguments by the defense attorney. He accused Trump's team of fundamentally rewriting the indictment. And he cited a previous ruling by who? By Tanya Chutkan in that January 6th federal case, rejecting those arguments explicitly. This is the very same argument that Tanya Chutkan rejected, that the appeals court in D.C. rejected, and that is now before the United States Supreme Court. In that case, it's going to be argued in April. It's this notion that somehow, First Amendment and immunity, other things prevent the prosecutions from going ahead. Tanya Chutkan explicitly also rejected the notion, in addition to the immunity notion, that the First Amendment protects these kinds of statements. The attorney said that Trump is allowed to make false statements in many circumstances, including in the political domain. What he is not allowed to do, and the reason why this criminal prosecution is here, the attorney said, is to employ his speech and his expression as a part of a criminal conspiracy. There's a difference between those two things. He's not being prosecuted for lying, the attorney for the state said. He's being prosecuted for lying to the government, referencing this very complex racketeering charge involving efforts to pressure state officials there to produce a slate of electors for Trump that would claim that he was the official victor in 2020. And again, this legal face-off comes after Willis said her team was continuing its efforts to prosecute. Plainly, Judge McAfee has given us the answer by virtue of the very conduct of these hearings, that he is not waiting. He is not waiting for the Court of Appeals to decide the issue about disqualification. He is going ahead, and he is going to be deciding these cases, the merits of them, not waiting for the Court of Appeals, and instead going to continue to oversee these cases as they go forward. All that pending in front of Judge Scott McAfee, determining whether or not indeed the comments made by Donald Trump were the zenith of protected speech, or much more likely, as the prosecutor's attorney said, not protected, but a part of a criminal conspiracy. A programming note for next week, we're going to chat more about lawyers, since we talked a lot about them this past broadcast. We're going to talk about John Eastman and other lawyers. We're also going to talk about Sam Bankman-Fried, just this past week, sentenced to a 25-year term for his violation of the criminal law. All of that coming up on our next weekend weekly broadcast of Amicus, a law review. Join us for that discussion going forward. Have a good week, everybody.